Hello. Now I'm going to read you uh, the paperwork that I got from my document preparer that tells the process of bankruptcy. This is kind of dry, but this will actually give you all the information that you need to know about whether or not to file bankruptcy. Process Bankruptcy Basics. Article 1, Section 8 of the United States Constitution authorizes Congress to enact uniform laws on the subject of bankruptcy. Under this grant of authority, Congress enacted the Bankruptcy Code in 1978. The Bankruptcy Code, which is codified as Title 11 of the United States Code, has been amended several times since its enactment. It is a uniform federal law that governs all bankruptcy cases. Procedural aspects of the bankruptcy process are governed by federal rules of bankruptcy procedure, often called the bankruptcy rules, and local rules of each bankruptcy court. The bankruptcy rules contain a set of official forms for use in bankruptcy cases. The bankruptcy code and bankruptcy rules and local rules set forth the formal legal proceedings for dealing with the debt problems of individuals and businesses. There is a bankruptcy court in each judicial district in the country. Each state has one or more districts. There is 90 bankruptcy districts across the country. Bankruptcy courts generally have their own clerk's offices. The court official with decision-making power over federal bankruptcy cases is the United States bankruptcy judge, a judicial officer of the United States District Court. The bankruptcy judge may decide any matter connected with the bankruptcy case, such as eligibility to file or whether a debtor should receive a discharge of debt. Much of the bankruptcy process is administrative, however, it is conducted away from the courthouse. In cases under Chapter 7, 12, or 13, and sometimes in Chapter 11 cases, this administrative process is carried out by a trustee who is appointed to oversee the case. The debtor's involvement with the bankruptcy judge is usually very limited. A typical Chapter 7 debtor will not appear in court and will not see the bankruptcy judge unless an objection is raised in the case. A Chapter 13 debtor may only have to appear before the bankruptcy judge at a plan of confirmation hearing. Usually the only formal proceeding at which the debtor must appear is the meeting of creditors, which is usually held in the offices of the U.S. trustee. This meeting is informally called the 341 meeting because Section 341 of the Bankruptcy Code requires that the debtor attend this meeting so that creditors can question the debtor about debts and property. A fundamental goal of the federal bankruptcy laws enacted by Congress is to give debtors a financial fresh start from burdensome debts. The Supreme Court made this point about the purpose of the bankruptcy law in a 1934 decision. It gives the honest but unfortunate debtor a new opportunity in life and a clear field for future effort, unhampered by the pressure and discouragement of pre-existing debt. Local Loan Company versus Hunt, 292 U.S. 234, 244, 1934. This goal is accomplished through the bankruptcy discharge, which releases debtors from personal liability from specific debts and prohibits creditors from ever taking any action against the debtor to collect those debts. This publication, and that's important, don't forget that part. This publication describes the bankruptcy discharge in a question and answer format, discussing the timing of the discharge, the scope of the discharge, what debts are discharged and what debts are not discharged, objections to discharge, and the revocation of the discharge. It also describes what a debtor can do if a creditor attempts to collect a discharged debt after the bankruptcy case is concluded. 6 types of bankruptcy cases are provided for under the Bankruptcy Code, each of which is discussed in this publication. The cases are traditionally given the names of the chapters that describe them. Chapter 7, entitled Liquidation, contemplates an orderly court-supervised procedure by which a trustee takes over the assets of the debtor's estate, reduces them to cash, and makes distributions to creditors, subject to the debtor's right to retain certain exempt property and the rights of secured creditors. Because there is usually little or no exempt property in most Chapter 7 cases, there may not be an actual liquidation of the debtor's assets. These cases are called no-asset cases. A creditor holding an unsecured claim will get a distribution from the bankruptcy estate only if the case is an asset case and the creditor files a proof of claim with the bankruptcy court. In most Chapter 7 cases, if the debtor is an individual, he or she receives a discharge that releases him or her from personal liability for certain dischargeable debts. The debtor normally receives a discharge just a few months after the petition is filed. Amendments to the Bankruptcy Code enacted in the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005 require the application of a means test to determine whether individual consumer debtors qualify for relief under Chapter 7. If such a debtor's income is in excess of certain thresholds, a debtor may not be eligible for Chapter 7 relief. Chapter 7, Bankruptcy Basics. This chapter of the Bankruptcy Code provides for liquidation, the sale of the debtor's non-exempt property, and the distribution of the proceeds to creditors. Alternatives to Chapter 7. Debtors should be aware that there are several alternatives to Chapter 7 relief. For example, debtors who are engaged in business, including corporations, partnerships, and sole proprietorships, may prefer to remain in business and avoid liquidation. Such debtors should consider filing a petition under Chapter 11 of the Bankruptcy Code. Under Chapter 11, the debtor may seek an adjustment of debts, either by reducing the debt or by extending the time of repayment, or may seek a more comprehensive reorganization. Sole proprietorships may also be eligible for relief under Chapter 13 of the Bankruptcy Code. In addition, individual debtors who have regular income may seek an adjustment of debts under Chapter 13 of the Bankruptcy Code. This particular advantage of Chapter 13 is that it provides individual debtors with an opportunity to save their homes from foreclosure by allowing them to catch up past due payments through a payment plan. Moreover, the court may dismiss a Chapter 7 case filed by an individual whose debts are primary consumer rather than business debts if the court finds that the granting of relief would be an abuse of Chapter 711 U.S.C. 707B. If the debtor's current monthly income, 1, is more than the state median, the Bankruptcy Code requires application of the means test to determine whether the Chapter 7 filing is presumptively abusive. Abuse is presumed if the debtor's aggregate current monthly income over 5 years, net of certain statutory allowed expenses, is more than $12,475, or 25% of the debtor's non-priority unsecured debt, as long as that amount is at least $7,025. The debtor may rebut a presumption of abuse only by showing of special circumstance to justify additional expenses or adjustment of current monthly income. Unless the debtor overcomes the presumption of abuse, the case will generally be converted to Chapter 7 with the debtor's consent or will be dismissed. 11 U.S.C. 707B, Section 1. Debtors should also be aware that out-of-court agreements with creditors or debt counseling services may provide an alternative to bankruptcy filing. Background: a Chapter 7 bankruptcy case does not involve a filing of plan of repayment as in Chapter 13. Instead, the bankruptcy trustee gathers and sells the debtor's non-exempt assets and uses the proceeds of such assets to pay holders of claims, creditors, in accordance with the provision of the Bankruptcy Code. Part of the debtor's property may be subject to liens and mortgages that pledge the property to other creditors. In addition, the Bankruptcy Code will allow the debtor to keep certain exempt property, but a trustee will liquidate the debtor's remaining assets. Accordingly, potential debtors should realize that the filing of a petition under Chapter 7 may result in the loss of property. Chapter 7 eligibility. To qualify for relief under Chapter 7 of the Bankruptcy Code, the debtor may be an individual, a partnership, or a corporation or business entity, 11 U.S.C. 101-41, 109B. Subject to the means test described above for individual debtors, relief is available under Chapter 7, irrespective of the amount of the debtor's debt or whether the debtor is solvent or insolvent. An individual cannot file under Chapter 7 or any other chapter, however, if during the preceding 180 days of prior bankruptcy petition was dismissed due to the debtor's willful failure to appear before the court or comply with orders of the court, or the debtors voluntarily dismissed the previous case after creditors sought relief from the bankruptcy court to recover property upon which they hold liens. 11 U.S.C. 109G 362D, from the bankruptcy court to recover property. In addition, so no individual may be a debtor under Chapter 7 or any chapter of the Bankruptcy Code unless he or she has, within 180 days of filing, received credit counseling from an approved counseling agency, either in an individual or group briefing. 11 U.S.C. 109-111. There are exceptions in emergency situations or where the U.S. trustee or bankruptcy administrator has determined that there is insufficient approved agencies to provide the required counseling. If a debt management plan is developed during required credit counseling, it must be filed with the court. One of the primary purposes of bankruptcy is to discharge certain debts to give an honest individual debtor a fresh start. The debtor has no liability for discharged debts. In a Chapter 7 case, however, a discharge is only available to individual debtors, not to partnerships or corporations. 11 U.S.C. 727A-1. Although an individual Chapter 7 case usually results in a discharge of debt, the right to a discharge is not absolute, and some types of debt are not discharged. Moreover, a bankruptcy discharge does not extinguish a lien on property. How Chapter 7 works. A Chapter 7 case begins with a debtor filing a petition with the bankruptcy court serving the area where the individual lives or where the business debtor is organized and has its principal place of business or principal assets. 3. In addition to the petition, the debtor must also file with the court 1. Schedule of assets and liabilities, 2. A schedule of current income and expenditures, 3. A statement of financial affairs, 4. A schedule of executory contracts and unexpired leases. Federal R. Banker P. 1007B. Debtors must also provide an assigned case trustee with a copy of a tax return or transcripts for the most recent tax year, as well as tax returns filed during the case, including tax returns for prior years that have not been filed when the case began. 11 U.S.C. 521. Individual debtors with primary consumer debts have additional document filing requirements. They must file a certificate of credit counseling and a copy of any debt repayment plan developed through credit counseling, evidence of payment from employers, if any, received 60 days before filing, a statement of monthly net income, and any anticipated increase in income or expenses after filing, and a record of any interest the debtor has in federal or state qualified education or tuition accounts. For example, a husband and wife may file a joint petition or individual petitions. 11 U.S.C. 302A. Even if filing jointly, a husband and wife are subject to all the document filing requirements of individual debtors. The official forms may be purchased at legal stationery stores or downloaded from the internet at www.uscourts.gov/bkforms/index.html.com. They are not available from the court. The courts must charge a $245 case filing fee, a $75 miscellaneous administrative fee, and a $15 trustee surcharge. Normally, the fees must be paid to the clerk of the court upon filing. With the court's permission, however, individual debtors may pay in installments. 28 U.S.C. 1930A, Federal R. Baker P. 1006B Bankruptcy Court Miscellaneous Fee Schedule Item 8. The number of installments is limited to 4, and the debtor must make the final installment no later than 120 days after filing the petition. Fed R. Baker P. 1006. For cause shown, the court may extend the time of any installment provided that the last installment is paid no later than 180 days after filing the petition. Example, the debtor may also pay the $75 administrative fee and $15 trustee surcharge in installments. If a joint petition is filed, only one filing fee, one administrative fee, one trustee surcharge is charged. Debtors should be aware that failure to pay these fees may result in dismissal of the case. If the debtor's income is less than 150% of the poverty level, as defined in the bankruptcy code, the debtor is unable to pay the Chapter 7 fees even in installments. The court may waive the requirement that the fees be paid. 28 U.S.C. 1930F. In addition, in order to complete the official bankruptcy forms that make up the petition, statement of financial affairs, and schedules, the debtor must provide the following information: a list of all creditors and the amount and nature of their claims, the source, amount, and frequency of the debtor's income, a list of all of the debtor's property, and a detailed list of the debtor's monthly living expenses. For example, food, clothing, shelter, utilities, taxes, transportation, medicine, etc. Married individuals must gather this information for their spouse, regardless of whether they are filing a joint petition, separate individual petitions, or even if only one spouse is filing. In a situation where only one spouse files, the income and expenses of the non-filing spouse is required so that the court and trustee and creditors can evaluate the household's financial position. Among the schedules that an individual debtor will file is a schedule of exempt property. The bankruptcy code allows an individual debtor to protect some property from the claims of creditors because of its exempt under federal bankruptcy laws or under the laws of the debtor's home state. 11 U.S.C. 522B. Many states have taken advantage of a provision of the bankruptcy code that permits each state to adopt its own exemption, law in place of the federal exemption. In other jurisdictions, the individual debtor has the option of choosing between the federal package of exemptions or the exemptions available under state law. Thus, whether certain property is exempt and may be kept by the debtor is often a question of state law. The debtor should consult an attorney to determine the exemptions available in the state where the debtor lives. Filing a petition under Chapter 7 automatically stays or stops most collection actions against the debtor or the debtor's property. 11 U.S.C. 362. But filing a petition does not stay certain types of actions listed under 11 U.S.C. 362b, and the stay may be effective only for a short time in some situations. The stay arises by operation of law, requires no jurisdictional action. As long as the stay is in effect, creditors generally may not initiate or continue lawsuits, wage garnishments, or even telephone calls demanding payment. The bankruptcy court gives notice of the bankruptcy case to all creditors whose names and addresses are provided by the debtor. Between 21 and 40 days after the petition is filed, the case trustee described below will hold a meeting of creditors. If the U.S. trustee or bankruptcy administrator 5 schedules a meeting at a place that does not have regular U.S. trustee or bankruptcy administrator staffing, the meeting may be held no more than 60 days after the order for relief. Federal R. Banker P. 2003a. During this meeting, the trustee puts the debtor under oath, and both the trustee and creditors may ask questions. The debtor must attend the meeting and answer questions regarding the debtor's financial affairs and property. 11 U.S.C. 343. If a husband and wife have filed a joint petition, they both must attend the creditors' meeting and answer questions. Within 10 days of the creditors' meeting, the U.S. trustee will report to the court whether the case should be presumed to be an abuse under the means test described as 11 U.S.C. 704b. It is important for the debtor to cooperate with the trustee and to provide any financial records or documents that the trustee requests. The bankruptcy code requires the trustee to ask the debtor questions at the meeting of creditors to ensure that the debtor is aware of the potential consequences of seeking a discharge in bankruptcy, such as the effect on credit history, the ability to file a petition under a different chapter, the effect of receiving a discharge, and the effect of reaffirming a debt. Some trustees provide written information on these topics at or before the meeting to ensure that the debtor is aware of this information. In order to preserve their independent judgment, bankruptcy judges are prohibited from attending the meeting of creditors. 11 U.S.C. 341c. In order to accord the debtor complete relief, the bankruptcy code allows the debtor to convert a Chapter 7 case to a case under Chapter 11, 12, or 13, Section 6, as long as the debtor is eligible to be a debtor under a new chapter. However, a condition of the debtor's voluntary conversion is that the case has not previously been converted to Chapter 7 from another chapter. 11 U.S.C. 706a. Thus, the debtor will not be permitted to convert a case repeatedly from one chapter to another. Role of the case trustee. When a Chapter 7 petition is filed, the U.S. trustee or the bankruptcy court in Alabama and North Carolina appoints an impartial case trustee to administer the case and liquidate the debtor's non-exempt assets. 11 U.S.C. 701, 704. If all the debtor's assets are exempt or subject to valid liens, the trustee will normally file a no-asset report with the court, and there will be no distribution of unsecured creditors to unsecured creditors. Most Chapter 7 cases involving individual debtors are no asset cases. But if a case appears to be an asset case at the outset, unsecured creditors, 7, must file their claims with the court within 90 days after the first date set for the meeting of creditors. Fred R. Baker, P. 3002C. A governmental unit, however, has 180 days from the date of the case is filed to file a claim. 11 U.S.C. 502B, subsection 9. In the typical no asset case, Chapter 7 case, there is no need for the creditors to file proof of claim because there will be no distribution. If the trustee later recovers assets for distribution to unsecured creditors, the bankruptcy court will provide notice to creditors and will allow additional time to file proofs of claim. Although a secured creditor does not need to file a proof of claim in a Chapter 7 case to preserve its security interest or lien, there may be other reasons to file a claim. A creditor in a Chapter 7 case who has a lien on the debtor's property should consult an attorney for advice. Commencement of the bankruptcy case creates an estate. The estate technically becomes the temporary legal owner of all the debtor's property. It consists of all legal or equitable interest of the debtor in property as a commencement of the case, including property owned or held by another person if the debtor has an interest in the property. Generally speaking, the debtor's creditors are paid from non-exempt property of the estate. The primary role of Chapter 7 trustee in an asset case is to liquidate the debtor's non-exempt assets in a manner that maximizes the return for the debtor's unsecured creditors. The trustee accomplishes this by selling the debtor's property if it is free and clear of liens, as long as the property is not exempt, or if it is worth more than any security interest or lien attached to the property, or any exemption that the debtor holds in this property. Long and dry. The trustee must also attempt to recover money or property under the trustee's avoiding powers. The trustee's avoiding powers include a power to set aside preferential transfers made to creditors within 90 days before the petition, undo security interest and other pre-petition transfers of property that were not properly perfected under non-bankruptcy law at the time of the petition, and pursue non-bankruptcy claims such as fraudulent conveyance and bulk transfer remedies available under state law. In addition, if the debtor is a business, the bankruptcy court may authorize the trustee to operate the business for a limited period of time, if such operation will benefit creditors and enhance the liquidation of the estate. 11 U.S.C. 721. Section 726 of the Bankruptcy Code governs the distribution of the property of the estate. Under 726, there are 6 classes of claims. Each class must be paid in full before the next lower class is paid anything. A debtor is only paid if all other classes of claims have been paid in full. Accordingly, the debtor is not particularly interested in the trustee's disposition of the estate assets except with respect to the payment of those debts which for some reason are not dischargeable in the bankruptcy case. The individual debtor's primary concern in the Chapter 7 case are to retain exempt property and to receive a discharge that covers as many debts as possible. A Chapter 7 discharge. Discharge releases individual debtors from personal liability for most debts and prevents the creditors owed those debts from taking any collection actions against the debtor. Because the Chapter 7 discharge is subject to many exceptions, Debtor should consult competent legal counsel before filing to discuss the scope of the discharge. Generally, excluding cases that are dismissed or converted, individual debtors receive a discharge in more than 99% of Chapter 7 cases. In most cases, unless a party in interest files a complaint objecting to the discharge or a motion to extend the time to object, the bankruptcy court will issue a discharge order relatively early in the case, generally 60 to 90 days after the date first set for the meeting of creditors. Federal R. Baker P. 4044004C. The grounds for denying an individual debtor a discharge in the Chapter 7 case are narrow and are construed against the moving party. Among other reasons, the court may deny a debtor a discharge if it finds that the debtor failed to keep or produce adequate books or financial records, failed to explain satisfactorily any loss of assets, committed a bankruptcy crime such as perjury, failed to obey the lawful order of a bankruptcy court, fraudulently transferred, concealed, or destroyed property that would have become property of the estate, or failed to complete an approved instructional course concerning financial management. 11 U.S.C. 727 Fed R. Baker P. 24005. Secured creditors may retain some rights to seize property securing an underlying debt even after the discharge is granted, depending on individual circumstances. If a debtor wishes to keep certain secured properties, such as an automobile, he or she may decide to reaffirm the debt. A reaffirmation is an agreement between the debtor and the creditor that the debtor will remain liable and will pay all or a portion of the money owed, even though the debt would otherwise be discharged in the bankruptcy. In return, the creditor promises he will not repossess or take back the automobile or other property so long as the debtor continues to pay the debt. If the debtor decides to reaffirm a debt, he or she must do so before the discharge is entered. The debtor must sign a written reaffirmation agreement and file it with the court. 11 U.S.C. 524C. The Bankruptcy Code requires that reaffirmation agreements contain an extensive set of disclosures described in 11 U.S.C. 524K, among other things. The disclosures must advise the debtor of the amount of debt being reaffirmed and how it is calculated, and that reaffirmation means that the debtor's personal liability for that debt will not be discharged into bankruptcy. The disclosure also requires the debtor to sign and file a statement of his or her current income and expenses, which shows that the balance of income paying expenses is sufficient to pay the reaffirmed debt. If the balance is not enough to pay the debt to be reaffirmed, there is a presumption of undue hardship, and the court may decide not to approve the reaffirmation agreement. Unless the debtor is represented by an attorney, the bankruptcy judge must approve the reaffirmation agreement. If the debtor was represented by an attorney in connection with the reaffirmation agreement, the attorney must certify in writing that he or she advised the debtor of the legal effect and consequences of the agreement, including a default under the agreement. The attorney must also certify that the debtor was fully informed of the voluntary made the agreement and that the reaffirmation of the debt will not create an undue hardship for the debtor or the debtor's dependents. 11 U.S.C. 524K. The Bankruptcy Code requires a reaffirmation hearing if the debtor has not been represented by an attorney during the negotiation of the agreement, or if the court disapproves the reaffirmation agreement. 11 U.S.C. 524D and M. The debtor may repay a debt voluntarily, however, whether or not a reaffirmation agreement exists. 11 U.S.C. 524F. An individual receives a discharge for most of his or her debts in a Chapter 7 bankruptcy case. A creditor may no longer initiate or continue any legal or other action against the debtor to collect the discharged debt, but not all of the individual debts are discharged in Chapter 7. Debts not discharged include debts for alimony and child support, certain taxes, debts for certain educational benefit, overpayments or loans made or guaranteed by a governmental unit, debts for willful and malicious injury by the debtor to another entity or to the property of another entity, debts for death or personal injury caused by the debtor's operation of a motor vehicle while the debtor was intoxicated from alcohol or other substances, and debts for certain criminal restitution orders. 11 U.S.C. 523A. The debtor will continue to be liable for these types of debts to the extent that they are not paid in the Chapter 7 case. Debts for money or property obtained by false pretenses, debts for fraud or defalcation while acting in a fiduciary capacity, and debts for willful malicious injury by the debtor to another entity or his property or another entity will be discharged unless the creditor timely files and prevails in an action to have such debts declared non-dischargeable. 11 U.S.C. 523C. Fedar Baker P. 4007C. The court may revoke a Chapter 7 discharge on a request of a trustee, a creditor, or a U.S. trustee if the discharge was obtained through fraud by the debtor, if the debtor acquired property that is property of the estate and knowingly and fraudulently failed to report the acquisition of such property, or to surrender the property to the trustee, or if the debtor, without a satisfactory explanation, makes a material misstatement or fails to provide documents or other information in connection with an audit of the debtor's case. 11 U.S.C. 727D. Note: the current monthly income received by the debtor is a defined term in the Bankruptcy Code and means the average monthly income received over 6 calendar months before commencement of the bankruptcy case, including regular contributions to household expenses from non-debtors and including an income from the debtor's spouse if the petition is a joint petition, but not including Social Security income or certain payments made because the debtor is a victim of certain crimes. 11 U.S.C. 101, Section 10A. 2. To determine whether a presumption of abuse arises, all individual debtors with primarily consumer debts who file a Chapter 7 case must complete Official Bankruptcy Form B-22A entitled Statement of Currently Monthly Income and Means Test Calculation for use in Chapter 7. The official forms may be purchased from legal stationery stores or downloaded from the internet at www.uscourts.gov/bkforms/index.html. They are not available from the court. 3. An involuntary Chapter 7 case may be commenced under certain circumstances by a petition filed by creditors holding claims against a debtor. 11 U.S.C. 303. Each debtor in a joint case, both husband and wife, can claim exemptions under the federal bankruptcy law 11 USC 522M. 5. In North Carolina and Alabama, bankruptcy administrators perform similar functions that U.S. trustees perform in the remaining 48 states. These duties include establishing a panel of private trustees to serve as trustees in Chapter 7 cases and supervising the administration of cases and trustees in cases under Chapters 7, 11, 12, and 13 of the Bankruptcy Code. The Bankruptcy Administrator Program is administered by the Administrative Office of the United States Courts, while the U.S. Trustee Program is administered by the Department of Justice. For purposes of this publication, references to U.S. trustees are also applicable to bankruptcy administrators. 6. A fee is charged by converting one request of the debtor, a request under Chapter 7, to a case under Chapter 11. The fee charged is the difference between the filing fee for Chapter 7 and a filing fee for Chapter 11, 28 U.S.C. 1930A. Currently, the difference is $922. Therefore, it is no fee for converting from Chapter 7 to Chapter 13. Unsecured debts generally may be defined as those for which the extension of credit was based purely upon the evaluation of credit was based upon the creditor's right to seize collateral on default in addition to the debtor's ability to pay. And then the further two copies was my non-attorney petition bankruptcy preparer papers. That was long and dry, but it's necessary to know what a bankruptcy is to determine whether or not you're even willing to do it. In most cases, most of your debt is going to be credit cards and hospital bills. That's what I was garnished over as hospital bills. My wife got sick and died. I went to court. I said, yeah, I had the hospital bill. My wife was sick and died. And they said, okay, well, you affirm that you owe this bill. I said, yeah, I guess. She was in the hospital. She was sick. So therefore, they automatically won. Since they automatically won, they started garnishing my wages. Now, garnishment is 25% of all your income before they take out taxes or insurance or 401k or anything. And so on a 2-week check, I might be making $1,300, but my actual take-home pay for 2 weeks was between $297 and $348 for almost a half a year. I was in a crippling situation. I had no way to pay an attorney. I hunted and hunted. I finally got a $2 raise not to quit my job. And when I got a $2 an hour raise, it only made my income, my take-home income, for 2 weeks, even getting several hours of overtime per week, my average take-home pay over the entire time was only $148 more in a 2-week period. Because even though I got a $2 an hour raise, they took 25% of everything that I had to begin with. My taxes went up, put me in a different tax bracket, and none of my other insurance that I was required to do went down. So my take-home pay was still basically nothing. this was for you to understand what a bankruptcy is. And the rest of the stuff is going to be very short, a little small video, and then some downloadable links. I thank you for your patience on that one. It was long and boring.